Thank you, Mr. Speaker. Mr. Speaker, the issues before this House have to do with a letter written by the clerk of the Parliament to the Electoral Commission dated 4 December 2025. In the letter, the clerk, Ebenezer Ehuma Jetro, had written to the chairperson of the Electoral Commission, and it reads, occurrence of vacancy in the membership of Parliament. And it said, in exercise of the powers conferred and the duty imposed on the clerk to Parliament by Article 112, Clause 5, as amended, of the 1992 Constitution of the Republic of Ghana, as amended, I, Ebenezer Ehuma Jetro, the clerk to Parliament, do hereby formally notify you of the occurrence of a vacancy in the membership of Parliament, occasioned by the order of the High Court, Tamale, for a rerun of the Panda parliamentary elections, given on the 24th day of November 2025. This notification is pursuant to the service of a court order on the clerk to Parliament as the fourth respondent in the suit numbered NR/HC/E13/22/25. Accordingly, notice is hereby given. Mr. Speaker, on the strength of this communication from the clerk to the chairperson of the Electoral Commission, the minority today, this morning, made a statement pursuant to the provisions on statements on urgent public matters. Mr. Speaker, when the minority chief whip made the statement, he demanded that the clerk be made to withdraw the letter he has written to the Electoral Commission. Mr. Speaker, I was not in the chamber at the time that the statement was made by the minority chief whip. I came in and I saw that the majority chief whip was on his feet and the members of the minority were on their feet behaving the very way that they are behaving now. And so I then urged the minority to allow for comments to be made, but they persisted behaving the way that they are behaving right now. Mr. Speaker, they continued behaving this way until the first deputy speaker, who was presiding, decided to get up on his feet to try and then bring order in the House. Mr. Speaker, he stood for a very long time, and they did not. They continued conducting themselves in the manner that they are conducting themselves now. And so the First Deputy Speaker took a short suspension and invited the leadership to conclave. When we went into conclave, the minority leadership refused to show up. They refused to show up, and subsequently, Honorable Habib came and said he had been mandated by the leadership to represent them in conclave. So in conclave, we tried to discuss the situation and to find out exactly what the problem was. It turned out, Mr. Speaker, that they said on the 4th, on Thursday, 27th of November, 2025, you had given a ruling regarding the rerun of the Kwandai parliamentary elections. And in your ruling, according to them, you had indicated that if the member for Kwandai exercised his rights to appeal, then that exercise of the right to appeal against the High Court decision will act as a stay on the execution of the orders or the judgment of the court. So the member for Kwandai had gone to file an appeal and had also filed an application for stay. And so, according to them, having acted on your indications in the chamber, they felt that the decision to allow the clerk to write to the chairperson of the Electoral Commission was not in good faith, and that was the basis of their objection. I listened to them, and so I called for the records, and I was given the Hansard, which captures exactly what you said on Thursday, 27th of November 2025. And Mr. Speaker, I want to read excerpts of your ruling and where they are basing their claims on, and then my responses to them. Mr. Speaker, you indicated on that day that honorable members, on Tuesday, 25th November 2025, the Legal Services Office of the House was served with an order from the Tamale High Court directed at the clerk to Parliament. Per the order, the court had ordered the second respondent, that is the Electoral Commission, to rerun the Kwandai parliamentary election within 30 days. Honorable members, this order arises out of the election petition filed by Daniel Nsal Wakwal, challenging the declaration of the Electoral Commission of Matthew Yindam as Member of Parliament-elect for the Kwandai constituency pursuant to the Kwandai parliamentary elections held on 7 December 2025. Honourable members, the effect of the order, to my understanding, is that the Electoral Commission is to conduct a rerun election within 30 days, implying that the original declaration of Honourable Matthew Yindam as the winner of the parliamentary election is invalid, and the member is no longer a member of Parliament. I, however, bring to the attention of the House the provisions of the Court of Appeal Rules 1997 CI 19 as amended in the Court of Appeal Rules of 2020 CI 132 Rule 27.3, and it provides as follows, and I quote, "There shall be a stay of execution of the judgment or decision appealed against for a period of 7 days immediately following the giving of notice of the judgment or decision." This rule appears mandatory in 8 terms and applies in every High Court decision capable of appeal. The Supreme Court in Mensa and Ghana Commercial Bank 2005 to 2006, Supreme Court of Ghana Law Reports on page 288 held that any execution commenced before the expiry of this 7-day period is premature and void. The Court of Appeal reaffirmed this position in Clenham Construction Limited and Falcon Crest Investment Limited and others, 7 April 2022, emphasizing that the purpose of the statutory stay is to allow the losing party the opportunity to consider the judgment and determine whether to appeal or seek further relief. Justice Bar J.A. explained that the position of the law does, and I quote him, "The plain meaning, scope, and effect of Rule 27.3b of CI 19 is that in respect of any ruling, judgment, or decision of the High Court of whatever description, in respect of which an appeal can be filed, and further, in respect of which an application for a stay of execution or proceedings could be filed, there shall operate a statutory stay of execution or proceedings for a period of 7 days. The apparent intent of the law is to enable the vanquished to ponder over and scrutinize the bona fides of the ruling, decision, or judgment in order to decide on whether or not to appeal. It is when a decision is made to appeal that an application can be made to the High Court under Rule 27.1a of CI 19 or to this court under Rule 27.1b of CI 19. Unquote. In this instance, the ruling of the Tamale High Court was delivered on 24th November 2025. The statutory 7-day stay, therefore, remains in force until 1st December 2025. During this period, the ruling of the High Court cannot form the basis for the Speaker to instruct the Clerk to Parliament to notify the Electoral Commission that the Kwanda seat is vacant. Mr. Speaker, you then added, in addition to the above, should Mr. Yindam exercise his right of appeal, such as an application under Rule 27.1b of CI 19, it may impose a further suspension on the enforcement of the judgment until the application is determined by the appropriate court. This rule appears to prevent the subject matter of the appeal from being altered or prejudiced while the appeal processes are pending. Therefore, before the initial 7-day statutory stay, the filing of a stay application may yet introduce an additional layer that may prevent changes to the status of the honorable member within the meaning of Article 97 and 99 of the Constitution. The attention of the House is also brought to Article 105 of the 1992 Constitution, which provides that a person who sits or votes in Parliament, knowing or having reasonable grounds for knowing that he is not entitled to do so, commits an offense, it is crucial to emphasize that Article 105 is penal in nature. Should the honorable member know that he ought not to be in the chamber and he participates in the activities in the chamber. Honorable members, it is therefore premature to say that Mr. Matuyindam is disqualified from entering and participating in the proceedings of the House, because this period still falls within the 7-day mandatory stay of execution of the order. Honorable members, this is not a declaratory order. It is an executive order that was delivered by the High Court. And so the honorable member is right to have been in the House yesterday and to have participated in the proceedings. So, Speaker, so this is what you delivered, and the minority are basing their arguments on the part of your ruling where you said, and I quote, "In addition to the above, should Mr. Yindam exercise his right of appeal, such as an application under Rule 27(1)(b) of CI 19, it may impose a further suspension on the enforcement of the judgment until the application is determined by the appropriate court. This rule appears to prevent the subject matter of the appeal from being altered or prejudiced while the appeal processes are pending." So, Mr. Speaker, their argument is that you appear to have given a ruling that the member is entitled to stay as a member of this House, and also that if the member did file any process in the courts, by virtue of having filed the process, then the member's right to remain is further fortified until the matters are disposed of by the court where the application for stay of execution or even the appeal has been lodged. So I called for CI 19 and CI as amended by CI 132. Mr. Speaker, and I read CI 132(1) to them. And CI 132 says that the Court of Appeal Rules 1997, CI 19, referred to in this enactment as the principal enactment, is amended in Rule 27 by A, the substitution for Sub-Rule 1 of, quote, 1, an appeal shall not operate as a stay of execution under the judgment or decision appealed against unless the court otherwise orders on an application made to the court by motion on notice, unquote. Mr. Speaker, I referred my friends on the other side to this provision of CI 132 and tried to indicate to them that filing an appeal or even filing a motion on notice will not automatically serve as a stay of the execution of an order of a court. And so, in the absence of a substantive order by the court, the clerk was not stopped from communicating to the chairperson of the Electoral Commission under the Constitution, because the chairperson is also obliged under the Constitution to communicate within a certain time period. So, Mr. Speaker, I then urge on our colleagues on the other side that we should come back to the chamber and they can restate their position, and I will also state this position as I have stated it, And on the basis of our positions, then we can invite you as Speaker to come and then give a ruling whether it was appropriate or in keeping with the law for the Clerk of Parliament to write the letter that he wrote to the chairperson of the Electoral Commission, which I have already read to the chamber. Mr. Speaker, I think that it will be appropriate to read Article 112 of the Constitution so that we can see what informed the action of the Clerk of Parliament, to see whether the Clerk of Parliament is in error or also acting pursuant to a constitutional obligation. So, Mr. Speaker, with your indulgence, let me read Article 1125 of the Constitution. 1125 of the Constitution says that whenever a vacancy occurs in Parliament, the Clerk to Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurred, and a by-election shall be held within 30 days after the vacancy occurs. Notwithstanding clause 5 of this article, a by-election shall not be held within 3 months before the holding of a general election. So, Mr. Speaker, clearly the Constitution injuncts the Clerk of Parliament, whenever a vacancy occurs in Parliament, the Clerk to Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurred, and a by-election shall be held within 30 days after the vacancy occurred. So, Mr. Speaker, so if we take the records, we notice that on 27th November 2025, 24th November 2025, you had indicated in your ruling that the statutory 7 days, stay, therefore remains in force until 1st December 2025. So once the statutory 7 days was enforced till 1st December 2025, it means that the obligation of the Clerk of Parliament will start counting on the 1st of December 2025. So within 7 days of December, the Clerk was obliged constitutionally, pursuant to Article 1125, to notify the Clerk. So on the 4th of December, the Clerk wrote to the Electoral Commission indicating that there was a vacancy because the Clerk had been served by the order emanating from the High Court indicating that the court had ruled that there should be a rerun of the election in the Kwandai constituency. So, Mr. Speaker, I think that what you are being invited to rule on here today is whether the Clerk erred in communicating to the Electoral Commission that a vacancy has occurred, and once a vacancy has occurred, that there should be a by-election in the Kwandai constituency. Mr. Speaker, especially your indication in your ruling that filing an appeal may elongate the period during which the member may be allowed to remain in the chamber. So, Mr. Speaker, that is basically what it is. That's all. Nothing really earth-shattering. And since morning, we've been having indications, negotiations, discussions, and we said that we should come into the chamber, and since they have indicated their position, we should also indicate our position. Now, in a normal democracy, with normal Democrats, people who actually believe in democracy, you would imagine that they will have no issue with us having this discussion in open parliament. But Mr. Speaker, I'm not surprised that we have this character of parliamentarians representing the minority side, and they are insisting that they don't want the discussions held in open parliament, that we should not be transparent about our arguments, that this side of the House should not be heard on this matter. And I have said it's not possible. No matter how much you chant, no matter how much noise you make, in fact, even if you come and stand on my seat here, I will still state my position so that the Speaker can give his ruling. So, Mr. Speaker, the issue before you is not to challenge your ruling. It is not to challenge your ruling, because your ruling was not even about what happens when one files an appeal. Your ruling was whether or not within the 7 days you could be called upon to remove the member of parliament from the chamber. If you recall, that was the main issue. And you ruled accordingly that by our CI 19, there is an automatic stay for 7 days. And so within that 7 days, the judgment could not be executed. The member will have a right to be in the chamber. But after the 7 days, then execution will be triggered automatically. So that ruling you gave, but then you engage in a general discussion of, some legal matters, and then you said that, if he triggers his appeal rights, it may. I think that the contention is around your use of the word may, and having used the word may, their position is that once he had filed his appeal and filed his motion on notice trying to secure an interim injunction, then we should not have allowed the clerk to write the letter to the Electoral Commission. But my contention is that that was not the gravamen of your ruling. The gravamen of your ruling was basically to decide that on that day the honourable member should stay in the chamber or not. And you did rule that he could stay in the chamber. Now, the issue of whether or not when he files an appeal and when he files a motion on notice for interim injunction, whether that serves as an injunction is a completely different matter. And I drew attention to CI 132, which amended CI 19, and which in its terms is very clear that once judgment is given, when you file an appeal or a motion on notice for stay of execution, it does not automatically stay proceedings in the execution of that judgment. So, Mr. Speaker, this is what you are being called upon to decide, and unfortunately, I am surprised that our friends on the other side will not want this fact to be stated so that Ghanaians will know why they are in black. Ghanaians will know why they are wearing face masks. They don't want Ghanaians to identify them individually. They are wearing face masks. They are wearing face masks. They don't want Ghanaians to identify them. If you are ashamed of what you are doing, remove your face mask. If you are ashamed of what you are doing, then don't do it. If you have the courage to do them, don't wear face masks to do them. I'm not wearing a face mask. I am very confident. And I can assure you that I will not be distracted. You can say anything about Boku, I will not respond to you. You can say anything, I will not mind you. I will remain focused. I will let the Ghanaians know that you are only pretending to be Democrats. You are not Democrats. Because if you are Democrats, you will allow Ghanaians to hear what is it that you are fighting. But you don't want Ghanaians to hear the facts, because you know that the facts are not on your side. You are fighting for justice, but you don't want Ghanaians to know the facts on the basis that you are fighting for justice. How will the Speaker rule if the Speaker has not heard all sides of this matter? The Speaker cannot rule. That is why since morning, my side has insisted that we will speak to the facts so that the Speaker can rule on the matter. And I am insisting that we will not allow this matter to be treated in secrecy. It must be treated in the full glare of the media. I want them to capture the facts based on which you are mounting your protest, so that Ghanaians will be the judges as to who actually is right in this matter. So, Mr. Speaker, basically, those are the facts. And I hear them talking about Boku. I will restrain myself today because His Royal Majesty, the Otumfuo, has indicated that he will bring the report on Boku on the 17th to present to His Excellency the President. When he presents his report to His Excellency the President, we will see where the matter will end. Mr. Speaker, on that note, I thank you very much.